Arundhati, are you there?
Yes, sir. I'm.
Okay.
Sir, is it audible? Hello.
It is audible. It is audible.
Okay, sir. So, good evening, everyone. Welcome to the second day of patent search in a program, 3-day workshop program that is conducted by the IPR cell of TKMCE. So, today the session will be conducted by Manoj Kumar D, sir. He is the patent search and specification analysis. He is a managing associate in the engineering department of Krishna and Saurastri Associates LLP. He is a registered patent agent and a member of the Bar Council of Tamil Nadu and Puducherry. He holds a bachelor's degree from electronics and communication, and also he is a specialist in the area of patent search and analysis. So it's my pleasure, and on behalf of IPR Cell TKMCE, Dr. Ansar sir, and all other members of IPR Cell and students, it's my pleasure to welcome you, sir, to this event. Welcome you, sir.
Yeah, thank you, Arundhati. Yeah. So, good evening, ladies and gentlemen. So, myself, I'm Manoj from Krishna Saurastri Associates. So, I'm basically an electronics engineer and associate partner working in this firm. So, I'll just show my presentation. I'll open my presentation.
Manoj sir, can you increase your volume a bit?
Volume. Hello.
Yeah, now it is fine. Now it is fine, sir.
Yeah, it is fine. Okay.
Okay.
1 second. I'll share my screen.
Okay.
So, everyone can see my screen.
It is not visible, sir.
But it is sharing. You can see my screen, sir?
No, sir, it is not coming. Sir, did you selected the entire screen?
Yeah, I selected the entire screen.
Sir, then can you share the PPT to me?
I'll continue. That is showing some error. Can you see my screen also?
Yeah, it is coming, sir. Yeah.
Yeah. So I'll start with a firm introduction. So we, Krishna Saurastri Associates, we established in the year 1992. Basically, it's a firm which has been established in the year 1956 by a single person, and then we are established as a law firm in the year 1992. So basically, our firm we are into majorly two main divisions. One division we are taking care of IP and technology division, and second is a general law practice. So we are one of the topmost leading law firm in India. So we take care of both domestic and international applicants. So we have our head office in Bombay, and we have a fully functional office in other locations like New Delhi, Bangalore, Pune, Ahmedabad, and in Chennai. And we have an associates all over India and all over the world. So in the IP and technology division, basically we take care of patent, trademark, and geographical indications, copyright, designs, trade secret. Mostly we'll cover all the IP and technology division in one division. And again in the general law practice, we take care of arbitration, competition law and etc. So basically, I'm in an IP person. I generally take care of IP and technology division, and general law practice has been taken care by fully by an advocate. We have another team for that. And when it comes to major IP services, like as I said, like patent, trademark, copyright, and other IP services, like in patents, generally we start from doing a search. We'll prepare a patent application. Like generally, everyone knows like patents, they will have a specification like professional and complete specification. We draft both the applications and then we'll file the application. And later on, we'll request the application for the examination and then we'll prosecute the application. In the prosecution, as we know, in the process, you will have an FER and hearing will come. So we'll attend to both of the FER and hearing and we'll prosecute the application. We'll get a grant for the application and then we do take care of renewals and then further doing the process in case of any opposition. Like before the grant of patent, in case if you have a pre-grant opposition, we do take care of opposition. And after the grant of the patent application, in case if you have a post-grant opposition, we take care of post-grant opposition and further validating the patent, invalidating the patent, filing infringement suit, and taking care of infringement. So we take care of from starting to till the end of 20 years lifetime of patent and more than that. Like in some cases, FPO will be it will be like there are some other things which we'll take care of after 20 year also. So we'll take care of from top to bottom. We do everything for patents. Similarly, we do it for others like trademark, copyright, and designs also. Coming to the session today, the session with like the topic which has been assigned to me is basics of patent search and reading how to read the document in view of the search. So coming to the patent search, generally like there are three categories, like three persons where they will do a search, like inventor. So inventor is like inventor can be an individual inventor or an inventor who will be working in a company like small scale industry, startup, or any large scale industries, or the inventor is from an any education institute. So they will generally do a search to check whether there is a duplication in the existing knowledge. So they want to like whenever they have an idea, so they want to check themselves whether we are duplicating the existing knowledge or not. In case if the idea is something unique, then we will go for the second process. So inventors basically they will check whether the idea is already there or not, or whether we are duplicating the existing knowledge or not. And then coming to the entrepreneur is like when they are coming into the business, they will check whether what competitors are generally doing, or what are the competitors where they are not going into certain areas. They will find the new trend in the business or gap, where is a gap to fill in themselves to be a success, get success in the market. So entrepreneurs will do that. And then researchers are the one who will generate new ideas, new technologies. Like as an electronics engineer, I'll tell like there is an improvement from the networking technologies from 2G, 3G, 4G, 5G. Now they are working on 6G technologies. So these researchers are the one who will work deep into the technologies to bring out new ideas. What they will do is like generally they will review the whatever the patent application which has been already filed by themselves. They will do that and they will do a deep research in the technologies and they will generate new ideas. Yeah, patent search why. So whenever you get an idea, you have to check whether the idea is worth to doing a search or not. When you do a basic search of the idea, you will get to know whether to develop this idea or not. So you have to design around your idea. So whenever you do a search, you will get to know whether it is duplicating the existing knowledge or not. If it is new, then you will check for the basic you will check with similar patterns regarding your idea. When you check a similar ideas of your invention, that time you will get to know there are similarities. You have to check whether the problem statement is same or not. In case if it is same, you cannot do anything. And in case if you are similar, then you want to identify how I am similar, how I am different. So you want to make a design around that. In what way, if I do, I will make it a success. So you want to differentiate whatever is already there in the art. If you are able to do that, then you will go to the next stage of developing your patent. So whenever you are having an idea, if an invention, so you want to identify whether it's a process idea or a product idea. So generally, patent will be granted for an invention where the invention should have a technical, like you should have a technical advancement in that. You should have a new process or new product having a technical inventive step into the invention. Then only like you can file a patent application. So here, and then you want to check, like I'm saying, it can be a process or a product. So process patent means like you will have a, like you will have some process. You want to show some new step into the process. You want to show some new and different technique in the process step, and then that can be called as a process patent. And in case of product patent, you will be in a product patent, you will be like generally the product will have different units. The number of units, the number of components will be there. So you want to show the difference in the component or in the units, how they are interconnected. So in that case, you can that can be called as a product patent. There are cases where the invention will lie both in the product and in process. In that case, we can cover the application in both process and product. So, but like whatever the thing, whether it's a process or product, you should have a in the invention you should have novelty, inventive step, and usefulness. In most of the invention, usefulness will be there. So novel means like the future should be new to the entire universe, not to the only one country. It should be the future should be new to the entire universe. And inventive step means like inventive step, you should because of that future, you should have some technical advancement in the future. If you are able to overcome these three process, then you are eligible to file a patent application. Before filing a patent application, they will do a prior search to check whether I can pass these three windows or not. And then deployment. Deployment in the sense like you will draft an application, you will file a patent application, you will prosecute the application, and you will get a grant. Like doing drafting an application, so you want to understand the marketability of the product, whether you want to claim that application in uh, uh, to process or in a product, to how many claims you want to draft an application. You want to make all the strategies before filing an application. During drafting stage, you want to make a strategy on which steps or which step you have to concentrate, or what are the things I have to cover in the claims. You want to draft a clear boundary of your claims, and then you have to file an application. Not only clear boundary in the specification, you want to speak about like whenever you develop an invention, like there is something called best mode of working of the invention. You should disclose what is the best mode of working of the invention in the claim, and then you want to disclose the alternative embodiments in the description. So, and whatever the claims you are drafting, like you should have some backup fallback position in the claims. During prosecution, if something happens, you can do an amendment to the claims, you can get a grant. So this is what the 4 stages will do to do a search and to get a grant of a patent application. So generally by do a patent search, what are the advantages we'll get? So we'll get a protection in legal and IP risk assessment. You will be able to check whether it's a patentability or not. You will be able to check whether your invention is your ideas or invention is having a novelty or not. And freedom to operate is a kind of patent search where you will have a freedom to launch the product or not in any of the country, and patent validity, enforceability. In the technology side, when you do a search, you will get to know what is the state of the art, which country is working on which technology, and which technology or which concept is growing in different countries. You will be able to identify the areas where you can concentrate, and you can identify the emerging technologies. And like in order to develop your business, like you will be by doing a search, you will be able to identify the like new market for the new technologies or the alternative market. Or like when you do a search, by doing a patent search, you will be able to connect with the person who is related to your invention. So similarly, like there are many things where uh, you can get it done by the patent search. And like how they do the patent search yesterday and now. So in the early 20th century, so whenever they want to do a patent search, it's a manual search. You want to go to the respective office and you want to manually check each and every document. Like the prior art search, like it will be divided into different sectors, like mechanical, electrical, electronics. You will have different sections. You want to personally, you want to go there and manually you want to check each and every document to check whether if there is any similarity to my patent or not. So and later nowadays like we have many like we have an electronic devices, we have a databases, we have a search engine where we can sit in a place and you can search in the databases to find out the relevant inventions similar to our concept, our invention or our ideas. So like um, patent searches yesterday versus today. So the burden of search was minimal on the inventor. Today, a thorough search is essential before entering a patent prosecution. Why? Because like the thorough search is very important because whenever you file an application, before that you want to like it's very important to do a prior art search whether you are able to pass the three windows like novelty, inventive stuff, and usefulness. So if you are able to pass these three windows, then you can file an application. So here, the why we are saying it is very important before entering a patent prosecution, like patent filings, starting from getting a grant, like it involves lot of funds into the patent application. So it's always better to do a search before, like after entering the patent. Also, it's better to do a thorough patent search whether you can pass these three windows or not. And then during the entire life of the patent, like multiple searches are required uh, during the life of a patent, which means like initially when you enter filing of the application, prior art search is very important. And then during a prosecution, controller will do a search and they will cite some prior documents where you want to able to differentiate with respect to the prior documents. You should have that unique feature in your invention to overcome those prior art. And then after getting the grant, like I said, like you will have a post grant opposition, pre grant opposition, like everything involves the patent search. Even after getting the grant, like they will validate your patent. So that time also there will be a search. And then if you want to file a suit on someone, then you will have an infringement search. So I'll explain you like what are the search generally involved in the process. Coming to the different type of patent searches, like there is number one is like prior art search or patentability search or novelty search. Second one is landscape search, and third is like validity search and invalidity search. Fourth one is FTO search, and then it's an infringement search. I'll explain you each and every uh, search in the upcoming slides. Prior art search. Since generally prior art search refers to any product, article, patent information, journals, publications, public discussion, anything in public domain. So prior art means like if anything is in there, if it is already there in the public domain in any means, it's not necessarily it should be a patent application. It's not necessarily it should be any publication. Like if there is any data which is similar to idea which is already there in the public means, then those documents, those data will be considered as a prior art search. So even your own publication, you have an idea and you prepare a document, and if you publish publicly in a public domain, then that document will be considered as a prior document for yourself. So generally, whenever you have ideas or new inventions, it's always better to file an application. Like you can file an application, either you can file a provisional application or you can file, if you have a full prototype with you, you can go for a complete application. So anything which is there, in the public domain, not only in India, it can be anywhere. Those documents or those data will be considered as a prior document. So that inventor or agent should aware of those data by doing a prior art search. So like I said, like before filing like at the time of development or before filing the patent application, you want to do a prior art search and you want to make sure that I will pass these three windows. Then you can file a patent application. This is generally a prior art search, or they call it a novelty search or patentability search. Yeah. So, it basically defines to determine the specific invention within the scope of patentable subject matter, like novelty, inventive step, and industrial applicability. Patentable subject matter means like this, like in the act, there is some section called 3. Like you should pass that 3 also to get a grant for your patent application. And like 3 is like there are some non-patentable subject matters. So your invention should not fall under those categories and then you want to overcome this novelty, inventive step, and industrial applicability, then only you will be able to file a patent application, and you can prosecute and you can get a grant for that invention. So determined whether any prior art, patent or non-patent publication exists in the world, would power issue the valid patent. And data source include expired or unexpired patent anywhere in the world. Like it's not necessarily that patent exists in the term of 20 years or the expired patent. It can be any data. They will be considered for the patentability search or prior art search. Coming to the landscape search. So landscape search, it's a kind of search where it will provide a potential idea to the inventors or the entrepreneurs or to the researchers during the research and development. So this landscape search will give an idea which technology is booming all over the country. It will be respective to the single region. Like it is focuses on single thing where in case of technology, in case of geographical area, in case of industries, like take an example, blockchain. Like it's a concept where like you are like by doing a search you will identify which concept is growing in which country. Like blockchain you can identify in US. So similarly there are like you take an example, when you do a landscape search you will get to know China is working on which technology, and similarly which industry is growing in which country. So this landscape search will useful in identifying the single like based on that countries will get to know what are the opportunities you will get for this product and service you are giving in respective countries. Like take an example, you have a product. So by doing this landscape search, you will get to know which country you can concentrate for that product. So this landscape search will give an idea where to concentrate and what to concentrate. Coming to the next one is like validity and invalidity research. Like validity search and invalidity search. So here, like you file a patent application and you get a grant for a patent application, and then if you sue someone for using the product, so what that infringer will do, they will try to invalidate your patent. Invalidating the patent means like they will do a search and they will get the document which is similar to your invention, and they will map claim to claim mapping they will do, and they will invalidate your patent. So similarly, invalidity is like the same process. They will do a search and they will check the similar patent which is there already in the art, and they will cite and they will invalidate your patent. So we do take care of both validity and invalidity. It depends on like what kind of search do you do. You do validity or invalidity search. Like you want to check what is this validity and invalidity research. It's a given patent valid. Given patent valid means like as I said, they will do a search and they will fill your patent application with the 3 windows. Like basically they will cite for the novelty. They will check if there is any prior art document or any document, any patent document or any document which speaks about the unique feature of your invention, granted patent. In case if it is there, then they will use that document to invalidate your patent application. So yeah. So next one is FTO search. FTO search is a search where like take an example, you have a grant of your like you got a grant for a patent, like or else you develop some product. So you got a grant for a product or process, or you develop some product. So before launching your product, you have to do a FTO search, which means freedom to operate. I should have a freedom to launch my product in a particular region, particular country. So before, like why we have to do this FTO search is like it's a clearance search. Whenever you launch your product, you should not get infringement sued by any one was granted with some patent. Like in an example, like take a product. In a product will have number of components or number of units. So you will have that unit to assemble a product. So whenever you are launching the product, so like take an example, like there are 5 components. Like we don't know whether that each component might have been like patented by some third party. Without analyzing that, when you launch a product, So there is a chance they may file an infringement suit on you. So like whenever you launch a product, you have to make sure that your components or product are free from any infringement suit by third parties. So you want to do a search. So it is like whenever you like it's a this freedom to operate is like it is restricted to the jurisdiction. Whenever you want to launch in India, you want to check whether the patent is still valid in India. It's not required that you want to check in other countries. Like if you want to launch in US, then you want to check whether you are free to operate in US or not by doing an FTO search. Basically, this FTO search will be useful in taking a decision whether to launch in that country or not, or identify patents that need to be licensed. In case there are 5 units where you feel that if this unit has been patented by someone, means then it will be like it will give an idea or it will give an option to licensing with the third parties to launch the product and to design to also design our own options to prove or assure that your proposed product or any invention does not violate or infringe any active patent. If there is a case where if the term of patent of third party is expired, then there is no problem. You can do that. But if he is having a right if he is having a right to file a suit, then he will file a suit on you. So it's better you do a search, FTO search before launching a product. That will be save a lot of investment in your for your product. So infringement search, why? So infringement search, when you got a grant for a product, so like if you find that any third party is using your product without your infringement, then you can file an infringement suit on them, or else like you can infringement search generally they will do like a search to identify the product whose technology infringements the technology of client's patent. So you want to check the like I'm having a patent product, so you want to check whether any third party is using your patent or not, your product or not. In case if yes, then you want to analyze the client product with your patent product in the claims, whether the product features are matching with claim features or not. So in case if yes, then you can file a suit on them. If not, you cannot file a suit on them. So this infringement suit will help in filing an infringement suit or will get avoid from the infringement suit for the third party. So like patent search, what is the process flow? Generally, whenever you do a patent search, you will do a search, like you will have an invention. In the invention, you will take the keywords from the invention and then you will do a search with certain operators and then you will will retrieve the documents from the database and then you will screen the documents. Like you will hierarchy wise, you will place the documents and then you will analyze the document and then you will give the report. So this is how generally the patent search flow works. So what are the patent database available? So there are free databases and paid databases. Like in case of like if you want to do a search by yourself, you can access the free databases like Google Patents, eSpaceNet, USPTO, Patent Scopes by WIPO, and there are some free patents online. It's one of the free databases, and there are some paid databases like Orbit Intelligence, Thomson Innovation. There are some paid database like Derwent and PatBase, PatSeer. So the difference between the free databases and paid databases is like paid databases, like you will have a lot of advantages. Like whenever you read a patent specification, it will be difficult for someone to understand. In the paid database, like you will have a lot of options where they will understand the patent, they will understand the specific patent application and they will give the summary of the patent. Or in a free database like eSpaceNet or USPTO, they will specifically they cover only certain countries into the free databases. Like USPTO, they will cover only the US applications. WIPO will cover WIPO applications and they will cover US, China, they will cover, but not all the applications. But when it comes to like, there is one more free database of India IP India patent search database also, where you will get to find the Indian patent applications in the database. But in the paid databases, you will get patent documents filed by all over the countries, and they will have you will have simplified understanding of the specific patent application. And further, they are like they may give suggestion how to do a search, how to generate the keywords, or how to like how to do a search. They will have all the things in the paid databases. Uh, and planning and conducting the searches. Like whenever you do a search, you want to determine the purpose of the search. Whether you want to do a like prior art search, patentability search, or whether you want to do a landscape search, whether you want to do a freedom to operate search, whether you want to do a validity search. You want to understand everything. In case of prior art search, you want to understand what is the crux of the invention, whether the invention lies in the process or in the product. So it's very important to understand where your invention lies, and then based on that, you want to generate the gather the necessary information and data to conduct a search. Necessary information is the search like crux of the invention, whether it is a process or product. In case if it is in a product, then you want to identify what are the components used in the product, and based on the units, you want to generate the keywords. Generating of the keywords, and then you have to determine when you frame all these things, you want to determine in which databases you need to search. Take an example why determining the database plays an importance. Like there are databases different for different technical fields. For chemistry, like you will have some specific database where they will cover more scope for the chemical invention. So similarly, determining of the database is also important, and then search strategy, and then perform a search. So, like during this process, when you do a search, if you are unable to get the relevant documents, relevant prior documents, you have to modify the strategy. Like search is a never-ending process. Like you have to repeat the search multiple times to get the relevant prior documents. And then after doing everything, you want to hierarchically you want to categorize the document, and you want to analyze, and you want to make a summary in view of whether in respect of these prior documents, whether my invention is having a novelty or not, whether it is having inventive step or not. So you want to do the analysis and summaries, and then we will report the results. Like generally when we give the report, we will say based on this prior arts, we will say that this invention is having a novelty, but it is not having inventive step when comparing multiple prior arts. So novelty generally state to state features will map in the prior art. So if there are features which is state to state map in the prior document, then it's a novelty killing document. In the inventive step document, it's not necessarily for the novelty, like we need one document which matches everything. For the inventive step, it's not necessary, it should be one document. Like by combination of document, you can cite it for the inventive step. So like inventive step is like when I read the two patent applications, like I will be having a motivation to come to your invention, they will disclose. So these are the categories we will categorize, and we will issue the report. Earlier I spoke about the operators, what are the operators generally they will do, they will have to do a prior search. So there are operators like are, and operator, and not operator. So whenever you have a keyword to do a prior to do a search, that time or operator they will use to check, it will expand the search. It will expand the search. Like each term retrieved will include either or both terms. Like or generally you will have, it will be having this or that. Like in an example, methyl alcohol or methanol. So you will, when I use the Boolean operator between these two, you will get all the documents which is having both the terminologies. Like it will expand your search. Or if you use a AND operator within this terminologies, you will narrow down the search. Which means, like in an example, if you use the AND operator between plutonium and isotopic, like you will get all the documents. You will get only the document which is having these two documents, two words, two terminologies, and not exclude the one term. Which example like cat, not dog means, like you will get the document which is having the cat word but it will reject the document which is having dog. So these are the three basic Boolean operators will be using when you do a patent search. So this is another example where like tennis and ball means like you will get all the documents which is having tennis and ball. And tennis and not means not ball means documents having the word tennis but not the word ball. Tennis or ball means like you will get the document which is having tennis and ball or sometimes both. So these are the three main Boolean operators we will be using in while doing a search. And this is just an example. When you use tennis separately and ball means like you will get all the documents. Tennis and ball means you can see that blue areas where you will get that was limited document. And similarly, tennis not ball means like you can see the like area where you are covering. You will cover only the tennis and not the ball. And tennis or ball means you will get all the documents. So here, like whenever you frame a keyword, so you want like in an example, if tennis or ball means that you will have a synonyms of the ball word. Similarly, you have to generate as much keywords from your invention. For that invention, you will have different synonyms for the each word, and with the word, by using that Boolean operator, you want to do a search. Whenever by using the keyword, you should not use a very broad search to cover many patent documents, or you should not do a narrow search also. If you do a narrow search, you will eliminate the prior document which is relevant to your invention. So it is very important to generate relevant keywords and relevant Boolean operators to do a search to get the relevant prior documents. And then there is something called truncation, like wildcards, like exclamatory, question mark, and percentages. Like if you use these truncations, like it's not necessary. You have to elaborate the full terms. Electric star, if you put means like this truncation will give the prior document which is having this the fulfill like ending the terminologies. And then whenever you do a prior search, like in a patent application, you will have something called international patent classification, cooperative patent classification, US classification. This international patent classification, it is from WIPO, and cooperative patent classification, it's a combination of EPO classification and US classification. And US classification is something which is developed by the US United States. So here, whenever you get a prior document, in the document you can see some classification, IPC. Like you will get a prior document which is relevant to your invention, and by seeing the IPC classification, you can have that classification into the keyword search, and you can refine the prior search. By doing this, you will get the document which is very similar to your invention. So this classification, what are the how these classifications are defined? Like you can see A63 B2100202. This is for the tennis technical field. So this classification code, it will be in all the prior documents. It will be in all the patent applications. Like A63 generally it will speak about class. A63B means it will be subclass. I'm just showing an example. What are the what this classification code will have? It will have class, subclass, group, subgroup, and etc. So like I'll go to the next slide where how it will be shown. Like in case A is the classification, then it will speak about human necessities. B is the performing operations transporting, and A will have the subclass, subgroup, and everything. Like in the next slide, you will see the subclasses. And similarly, if you go to the next one, then you will have it will have a broad terminologies, and then it will refer into each and every field, and then to the specific feature, the classification code will speak. So in case if you find any product which is relevant to your invention, then it speaks about the particular feature of your invention. Then that classification can be used into the keyword to still narrow down the search, and you will get more relevant product documents. And when you do a patent search, the keywords you will be using for a prior search, and similarly there are many information we will be using to do a patent search. we'll take the information of inventor, assignee, when the patent application, when the patent has been filed, and in the below you can see search inventor, inventor Suresh, and assignee search. It can be any kind of engineering college, and search before and after filing date. Like you will have a restriction, like you will based on the search, like for the FTO, like you have to check whether the uh, patent application is alive or not. So you will have a limitation of 20-year. You want to check the patent which is within 20 years only. If not, if it is beyond 20 years, then you no need to worry for the FUO search. Similarly, you will have a date restriction also you can do, or you can restrict the search by doing the selecting the country origin. You can select by India. You will get only the India patent documents, or you can select any other countries where US means you will get only US documents, or you can restrict by using the patent status. Whether it's like if you want to see only the published patents, you can restrict with published, or you can see if you want to see only the granted patents, you can restrict with granted. The grant by selecting grant, and by the language also you can select and you can read the document. Rather documents. So when you form the keywords, generally what to use and what not to use. So with the different keywords, you want to use the and operators like tennis and ball. Because if you have a tennis ball, then you need to have the keywords, different keywords like tennis and ball to get the relevant prior art for your tennis ball. And you can use the or operator between the synonym of a keyword. Like for a tennis or a ball, it's just an example. Like if you have one keyword, you can use the or operator between the synonym of the keyword. So when you do that, you will explore other terminologies also to get the relevant prior document. But you should not use the or operator between the different keywords. Why? Because when you use the or operator between the different keywords, it's a never ending process. It will be too broad. It will give both the tennis and both the ball prior documents, which will never end your prior search process. And you should not use the and operator between the synonyms of the keyword. When you use the and operator between the synonym of your keyword, then your search will be too narrow, and you will miss out some important prior documents by doing these things. So you should not use or operator between the different keywords, and you should not use and operator between the synonyms of the keyword. Like when you formulate keywords to do a search. So like these are the different strategies you will be followed when you do a prior art search. So like that other thing is like where to look for the information. Generally, when you screen a patent application, that time like you generally if you have an invention, in the invention you will have some kind of title with you. So with the title you want to read the when you do a search with different keywords or different alternatives of the keywords or any synonyms of the keywords, you will get some paragraphs in the search itself, and then you want to read the title of the invention and the abstract. You will get to know whether it is relevant to our invention or not. And then after doing this reading the title and by reading the abstract, and then if it is relevant, you will make a category wise that yeah, this is relevant, and then further filtering out the document. Like when you do a search, you will do a search with a different set of keywords. You will have one set of keyword search, and you will get to know how many search you are getting. Similarly, you want to frame another set of keywords and you want to do a search. By doing this way, you will get to know how many paragraphs you are getting. And by reading this title and abstract, you will be screening the document. And then further, you want to read the document to understand whether it is relevant to my invention or not. So when you read the claims of the prior documents, you will get to know whether the prior documents are relevant to my invention, which means like you want to read the claims of the prior document to speak whether the keywords are there or some my features are spoken in the in the prior documents or not. In case if that is the case, you want to if it is similar, then you read the technical problem statement whether it is speaking about your technical problem or not. In case if it is yes, then you want to read the description to find out whether what is the specific feature you have covered in the invention, it has been disclosed in the specification or not. It not necessary it will be in a claim. It can be in any part of the specification of the prior document. In case if you have an invention, if it is not disclosed in the claims, it does not mean that you can file a patent application. You want to read the entire specification to find out whether the alternative embodiment has been covered in the specification or not. Uh, not whether it has been covered or not, to check uh, whether it has been disclosed in the specification or not. It is very important to read the detailed description also, and then you want to see drawings and legal status of the patent application. For the prior search, legal status is not required, but for the other kind of searches, like for FTO, legal status is very important, whether it is still valid or not, it is expired or not. You want to check the legal status of the patent application. So drawings also, like there are cases where if you are not able to find with respect to the keyword, by seeing the drawings, you can check the relevancy of the patent application. So these are the ways you want to check each and every section of the patent application uh, to understand whether our invention is disclosed in the prior art or not. Uh, so if you want to ask anything, like if you have any doubts in the slide, you can ask me, or if you want to understand any strategies, or if you have any doubt in doing a search, or what are the database you can cover, if you have any doubt, you can ask me.
Sir, can you show a demo
Demo you want?
with a simple example?
Yeah, yeah. Yeah. You can see my screen, sir.
It is coming, sir. Yeah.
Yeah. So whenever I'm like from the slides, I'm using the keywords tennis or ball. So whenever you do a search for tennis ball, which means like it will cover both the keywords and it will give the results. Like it is showing more than 10 lakh results. So when you use with the Boolean operator, sir, like it will have the like it is showing more than 10 lakh documents, but it will filter the documents. So if you see the keyword of tennis and not ball, which means it will have the word of tennis and not ball. So if you see the results, it narrowed down the search to 27,991. So by using this, like if you want to do a search, if you want to do a search for tennis and ball, like you will get lot of prior documents, and by using a keyword, I'll show you an example, sir. Not having an example currently with me, but by using the keywords, you can narrow down the search. You will get the documents only related to tennis and not ball. This one is like tennis or ball will broaden the search. It will give 10 lakh search results.
Hello, teacher.
Yeah, 1 second, sir. Sir, I'll just add some keywords to filter out. Like I will show you an example, like how the filtration will happen, sir. Like take an example. If there is a invention you have in 60 technology, which is happening between the base station and user equipment, sir. So you will have a keywords like you will have wireless communication, like you can for the 6G, like take an example. If you have a invention lies in 4G, like they can call us 4G technology, or they can call us LTE technology, like long term evolution. So this can be another keyword. And you can use user equipment another keywords, like you can use a terminal device, they can use mobile phone, or they can use some other computing device. For the base station, like the example of other keywords are like it can be a um, network device, server device, mobile tower. So these are the alternative keywords for the particular base station word. And similarly, you will have a keywords for the user equipment. When you develop this keyword, you can refine your search or you can elaborate your search. So I will show you an example, like how this filtration of document will happen in via search. Sir. You can see my screen, sir. Hello.
Hello, sir.
You can see my screen, sir.
No, sir. No. Yeah, now it is coming, sir.
Now it is completed. So generally, like when you do a Google patent, so if you want to find if you have an invention in battery saving in the user equipment, sir. So I'll do a search. Like you will say battery, and if you like it is a saving, so you will say battery saving, or you will like battery. If you say or energy saving, you can use R word here. I'll put here battery saving. So like you will get the document which is like you can see a method for expanding mobile communication function of portable device and method capable of realizing electricity saving of mobile. So this is the relevant paragraph, sir. So you want to read this document. What is the future they're using for saving the battery of your mobile phone device, sir? Or else if you use the keyword in between battery or energy, so energy saving, sir. So if you will get the document, if you see apparatus for selectively coupling an electric storage device or light device system and method for controlling and locking mechanism of using a portable device, because the keywords which I'm using here is like limited battery saving and mobile phone. So you will get the prior document which will have all these three keywords, sir. It can be not only to the battery saving, it can be for anything. So if you want to limit the document, you can add further keywords into the search to limit the document where you are searching, sir. Take an example. I'm putting base station. So now you can see the limitation of you will get only 247 documents, which means like you will get the prior document which is speaking about battery saving mobile and base station. So like it can be energy saving mobile and base station. So whenever you do a search, like this is the two terminologies. Like generally they can write as a battery saving or energy saving. So here saving you will have a other synonym word. Mobile is a too narrow term. You can use the if you use the in an example if I put the terminal, sir. To put a terminal, the number again it is coming to 144. If you use the other keyword, so again this is the other these are the technical terms. When you use the different synonym of the particular word, your number of results will vary accordingly. And so if you want to find out all the documents, then you have to use Boolean operator here. Use the terminal, mobile, or terminal. So now you will get the number will be different. So like similarly, like you have to do you have to frame a keyword. If possible, you can have a synonym for the keyword, and with Boolean operators, you can read the documents. Whenever you read the documents, you have to read like in the abstract, you have to read on which technical feature like if you see you are checking for electricity saving of a mobile communication terminal, compressing a starting unit and so on so. So you want to read and understand by which feature they are saving an electricity, the electric saving of a mobile phone device. If there is a case, if there is a similar technique if you are using, so you have to differentiate from that how you are having an invention to have electricity saving. So by having these differences, and if you have a technical difference clearly, then you can file an application. Sir. This is one of just an example. Like it depends on the it depends on the invention and how much keyword you generate on the for the invention. Sir.
Okay, sir.
So if you want to ask anything related to patents or any technical doubts on IPR, you can ask me, sir.
Any queries from the participants?
It's always better whenever you have an invention. It's better to have a prior search because at the later period of before the grant of patents or after the grant of patents, it will save a lot of investment by doing a prior search. Like when you file an application, you prosecute an application, and then during prosecution, if you get some patent document or any prior document which is relevant or which is similar to a patent application, like it's very mandatory, you have to differentiate what feature is different from the prior art. If you are unable to differentiate with respect to the prior art, then technically, if you are unable to differentiate, then you will not get a grant for a patent application. Even if you get a grant for the patent application, in the litigation, it is difficult to have the rights of the patent.
Okay, sir. Any queries from the participants? Thank you, Manoj sir, for your detailed explanation on patent search. That was a very informative session. And hope we can contact you in the future also for any doubts regarding patent search and for any patent search. Yeah.
Any IPR queries, you can reach out to us. Only important thing is like when you have a invention, it's better you do a better product search and draft the application in a proper way, because when you if you are not doing a proper drafting of a patent application, and during prosecution stage, it will be difficult for us also to handle the application, sir. It's always better when you have an idea. So if it is worth filing a patent application, do a search and then draft the application properly and then get it filed, sir. And when you file an application also, you will, it's not necessary that you want to have all the features novel inventive, but you should have some, not only one feature you should not have. So you should have some backup feature to get saved in the prosecution stages, sir. So like you should have that proper claiming also, so that you can do an amendment during prosecution and you can get a grant for a patent application.
Sir, if we are, sir, when we are doing a patent search, if it is identified that there is no novelty, we can also work on our project and have some innovative steps so that we can have some new additions to our original work. That is also, I think, by the help of
by doing the search, definitely, that is what, sir. When you get a similar patent application, when you get a similar paragraph search, so you can refine your invention in a better way, sir. But it's very important. It is very important at whatever the stage it is very important. You have to differentiate with respect to the paragraph document, sir. If you are unable to if you are unable to overcome the paragraph document, then it's difficult. So you should have the unique feature in your invention. That unique feature will have the technical, should have the technical advancement, sir. Then only at whatever the stage it is, it's not about getting a grant. You have to get you should have that economy out of the patent, sir.
Yeah, it is clear, sir.
Yeah. Okay.
So, any queries? You can also type in the chat box. If you have any queries, you can also type in the chat box. Okay.
And the search, I think the search is never-ending process, sir. Like when we do a search, we'll get some relevant prior documents. But when patent office does, they will also get prior document which is similar to our invention. In each and every stages, like after patent application, we'll get the search. It may be the same or different prior documents we may get, but we have to be clear on our feature, which feature we are claiming the invention.
Shafiq sir, are you here? Shafiq sir? I think he left. Okay, Vandana?
Yes, sir.
Okay.
Am I audible?
Yeah.
So, good evening, everyone. Thank you, Manoj Kumar sir, for the insightful session on patent search and specification analysis. The session was really useful for each one of us. Our sincere thanks to IPR Cell, TKM College of Engineering, for organizing this workshop. We also appreciate all the active participation of each one of the participants present in this session. Thank you.
Thank you, sir.
Yeah, thank you. Thank you so much.
Okay, thank you all.